Have you ever been watching a city council meeting and suddenly the council says, "We're now going into executive session." Then all the elected officials leave the room, the cameras stop, the doors close. You may be left wondering, what just happened? What are they discussing behind closed doors? Hello, I'm Danielle, and today let's break down what executive sessions actually are under Georgia law, what officials are allowed to discuss privately, what they are not allowed to discuss privately, and why this matters to the public. Because understanding government procedure is one of the most important parts of understanding local government itself. Under Georgia's Open Meetings Act, government meetings are generally required to be open to the public. That law exists because Georgia recognizes that open government is essential in a democratic society. But the law also recognizes that there are a few limited situations where a government body may legally meet in private. That private portion of a public meeting is called an executive session. Now here's the important part. Executive sessions are the exception, not the rule. Officials cannot simply go behind closed doors because a conversation is uncomfortable, controversial, political, or embarrassing. Georgia law only allows executive sessions for specific topics listed in the law itself. Some of the most common lawful reasons include discussing pending or potential litigation with attorneys, certain real estate negotiations, and limited personnel matters like hiring, discipline, evaluations, or dismissal of employees. But even then, there are rules. A city council cannot simply disappear into a back room without explanation. Before entering executive session, the public meeting must remain open. A majority vote must happen publicly to close the meeting. And in plain English, they must publicly state why they are closing the meeting. The law also requires that the reason for the closure be entered into the official minutes. Then something else happens that many citizens never hear about. The presiding officer, or in some cases each member present, must sign a notarized affidavit stating under oath that the executive session only discussed topics legally allowed under Georgia law. And yes, that affidavit becomes part of the official government record, which raises an important question. Can the public request that affidavit under the Georgia Open Records Act? Generally, yes. The Open Records Act says all public records are presumed open for inspection unless specifically exempted by law. The affidavit itself is part of the official record documenting that the executive session complied with the law. So while the detailed private conversation inside executive session may remain confidential under certain legal exceptions, the existence of the executive session, the stated legal reason for it, and the affidavit documenting it are generally public records. That's important because transparency does not completely stop just because officials enter executive session. There is still documentation, there is still accountability, and citizens still have rights under the Open Records Act to request many government records. That's why in a separate video we cover Open Records Act. You should check it out. The Open Meetings Act governs when meetings must be open. The Open Records Act governs access to government records. Together, those two laws form the foundation of what many people call Georgia's Sunshine Laws. Now here's another very important point. Even during an executive session, there are limits. Government officials generally cannot take binding, final action behind closed doors. In many cases, any official vote must later happen publicly in open session. So if officials discuss a lawsuit settlement, land purchase, or personnel issue privately, the actual public action often still has to come back into the open meeting. That distinction matters. Discussion may happen privately in limited situations. Official action generally must happen publicly. Now let's talk about what executive sessions cannot become. They cannot become secret strategy meetings for political maneuvering. They cannot become a way to avoid difficult public conversations. And they cannot become a loophole to discuss general city business outside public view. Georgia law specifically warns against gatherings designed to evade the Open Meetings Act. And if discussions drift into topics not legally allowed in executive session, the presiding officer must immediately rule the discussion out of order. If the improper discussion continues, the executive session must immediately end. So why does all this matter? Because trust in government depends heavily on transparency. Most citizens understand there are some situations where privacy may be necessary, but citizens also expect government to follow the law carefully, especially when meetings are closed to the public. That's why the Open Meetings Act tries to balance two things: the public's right to know and the government's limited need for confidentiality in specific situations. One sentence takeaway: executive sessions are legal under Georgia law, but only for specific reasons, under strict procedures, with public documentation, and not as a blanket excuse for secrecy. Be sure to check out some of our other videos where we help you better understand your local government. Thanks for watching.